Hi, everyone. Thanks again for joining us for another episode of the Fen Talks podcast. Heather Macre is joining us today. She is a director in our Phoenix office and happens to be our healthcare practice group leader. And on today's episode, we're talking about healthcare law, what physicians need to know. You know, there are a lot of great physicians out there. It seems like everybody knows either a lawyer or they know a physician, a doctor, whether we grew up with them, went to college with them, met them in our professional journey. And so just curious, do you mind just explaining a little bit more about the types of physicians that you regularly work with?
Absolutely. So I represent with physicians really across the spectrum. I also work with nurses, physical therapists, chiropractors, you name it, we've probably worked with it. And what we do is we like to help healthcare professionals navigate the often evolving regulatory landscape so that they don't have to worry about compliance issues. They don't have to worry about legal issues, and they can get back to doing what they love, which is treating patients. So that's really my goal. The other great thing about being here at Fenimore is that we are able to offer all of our healthcare clients a really holistic portfolio. A lot of healthcare clients don't always understand that because of the way the laws are structured, everything from leasing to hiring a new employee has some specific healthcare law component. And so we can really help them with everything from finding an office, growing their practice, shrinking their practice, choosing a new EMR system, mergers and acquisitions. And that's one thing I love about Fenimore is that there's almost a part of the law, there's almost no parts of the law that we don't touch upon and that we cannot help our medical community deal with.
So now let's talk about from a geographic standpoint. The great thing about podcasts is we could have listeners tuning in from all over the world. So from that standpoint, Heather, is there any specific markets that you commonly serve, or is there any that you don't serve?
So I am based here in Phoenix, and I represent healthcare professionals throughout Arizona. We also have healthcare lawyers that I regularly interface with, especially as the head of the group in Nevada and in California. We have had a presence in Denver and the Colorado area. Healthcare law is really interesting because a lot of the broader healthcare laws are federal, meaning that they have the same applicability nationwide. There are some state-specific healthcare issues, especially in California. So if we're dealing with those types of issues, I definitely make sure that the client gets to someone who is in California and sort of specializes in that. But there's actually quite a bit of work that we can do throughout the Southwest region. And we do like to help clients either get them to someone in the region that we can work with or their national questions that we can deal with wherever we're situated.
Now, healthcare leaders, thank goodness for them throughout the course of 2020 and 2021 with navigating, COVID-19. We sing their praises on a regular basis at Fenimore and often recognize them through our social media platform. But, there are individuals that need to look out for these healthcare providers' best interests. And that's one of the great things that we can do at Fenimore. So do you have any lessons learned from COVID-19 that you would like to bring to light and share with some of these professionals to help protect them and also to help guide them? Because maybe they're just coming up from air after this pretty hectic last couple of months.
COVID was an interesting challenge. I can't say that I personally had ever prepared to guide healthcare providers through a once-in-a-lifetime pandemic. But we really sprung into action here. We presented a lot of webinars and a lot of great content that's still available on our website. And so what we've been doing is a lot of consulting. We were helping both healthcare providers as well as elder care facilities keep up with the rapidly changing OSHA guidance from the World Health Organization, guidance from OSHA, and we continue to do that. We've also continued to keep them as updated as possible on some of the new laws that we're seeing regarding liability during COVID and, when these providers will have a defense based on something in a statute. So we've been doing a lot of that work. Another one that I've been dealing with more recently, as we are starting to see the pandemic, hopefully fingers crossed, kind of start to taper off, is working with the fact that during the pandemic, HIPAA and high tech were relaxed. This made a lot of sense during the pandemic. People needed to still have their regular healthcare needs met. And one of the great ways to do that was telehealth. We saw a massive expansion in telehealth all over the country. I think a lot of that is here to stay. But what we are advising providers on now is that once the pandemic national emergency is finished, and frankly, that declaration could come almost at any point now, that they need to make sure that their systems and platforms are HIPAA and high-tech compliant. So even though in the past, maybe they've been using a system that they like, it's time to go back and sort of re-audit those systems and making sure that what they're using is compliant, because we're not going to see these relaxed regulations going forward. Another thing that a lot of telehealth physicians are dealing with that's a little bit outside of healthcare law, but something that we've been dealing with a lot, is that if they're taking payments online, they need to make sure that their payment processing systems are HIPAA and high-tech compliant, and also compliant with the national rules that apply when you take any type of credit card payment over the internet. So it's been an interesting space where, again, we've been able to bring in a couple of different disciplines to really help our clients in a comprehensive manner.
I think you bring up some great points and probably some items that individuals haven't even thought about. So thank you for sharing some of that. I am not a healthcare expert myself at all whatsoever, but there are a couple laws and things that have popped up as of late. And so I would love to get your thoughts on all of these and how this impacts the healthcare industry. And one of them being the Stark Law. Would you mind expanding on that one specifically?
So the Stark Law is really interesting. It started in the 1990s as a response to physicians basically owning their own labs and potentially over-treating patients by running their own labs and benefiting from both seeing the patient and then referring them. What it is it's a complex regulatory framework that focuses on physician financial relationships as well as the financial relationships of the direct family members of the physician. So you can't have your brother own the lab and get around Stark. And sort of looking at whether or not physicians are allowed to refer certain services and then receive any type of fee in return for that referral. Now, it sounds very narrow. It sounds like it's really focused on fees for referrals. But the way that Stark has evolved is it really touches on almost every aspect of the healthcare practice. If you are a healthcare provider renting office space from another healthcare provider, Stark laws actually come in and say that you need to have that lease in writing. It needs to be for 1 year and more. It needs to be for fair market value. Even if you're doing part-time leases where you're only leasing space for, say, a day, you literally have to go through and crunch the numbers and figure out what the utilities are for that one day, what the parking ratios are for that day. So Stark really touches on everything. It touches on durable medical equipment issues. It touches on laboratory services. It really touches on any time that you are providing a healthcare service that may be paid by a government-funded healthcare program. So Medicare, Medicaid, TRICARE, Bureau of Indian Health Programs. It's extremely broad. Now, the great news that we have is that Stark has been loosened up a little bit this year. The Sprint regulations have been really kind of bouncing around Congress for a long time. They were finally passed, and many of them became applicable in January 1st of this year, though there are some specific regulations for group practices, which are groups of physicians that practice together and are allowed to share certain types of referrals back and forth. Those won't go into effect until next January. But we've been working with clients because what the Sprint regulations do is they shift the focus away from just a pure focus on referrals to focusing on value-based care. And that's a really big trend in the healthcare industry, value-based care. It places a new emphasis on preventative care and on looking at patient outcomes. So it is actually allowing for a lot of new and different business structures that might have been illegal under the previous version of Stark, but if you can link them to certain types of positive patient outcomes, like, for example, reducing hospitalizations, there are certain ways that you can structure your entities now to actually have some referral fees flowing back and forth. They are fairly narrow. They are fairly new. I will also warn folks, there are about 1,600 pages of the Sprint regulations. So when I say that they touch on a lot of things and there are a lot of new structures to deal with, this is a great place where if you have questions or you maybe want to change your business model, consulting not just with an attorney, but with an accountant and making sure that you've got accountability built in is really important. So the Stark laws are out there. They're definitely a trap for the unwary. The penalties under Stark are high. They can range from the low end of $100 per violation per day up to $50,000 to $100,000 per violation per day. So we're looking at pretty high consequences for practice. Stark also works in tandem with the anti-kickback law. The anti-kickback law is a federal law. It is very similar in that it looks at healthcare fraud and abuse in business relationships within traditional healthcare, pharmaceuticals, and medical devices. The big difference with the anti-kickback statute is that it is a criminal statute. So there are civil penalties, but there are also criminal penalties within it. It's also a little narrower than Stark. So you might be in a Stark exception, but not within the exact same safe harbor with an anti-kickback. It is something where there needs to be an in-depth analysis going in before you get into the business relationship to make sure that you're compliant with both, because even though they seem to cover a lot of the same issues, the specific safe harbors and exceptions are not the exact same. So that's a lot of what I do. And I work quite a bit with our business team, with our mergers and acquisitions team, with our finance team. They're all amazing people, with our tax attorneys, which is an awesome thing to have here at the firm, to make sure that when we are structuring these businesses, they are not just compliant with healthcare law, but they also work with other business regulations, and they also work for your business. You know, what are the tax implications of this? What are the finance implications of this? Because sometimes something that might work for me as a healthcare lawyer might not actually be the most profitable for a healthcare business.
I really appreciate you, doing that deeper dive specifically on Stark Law and helping to further explain that, as well as the anti-kickback statute. There's a lot of great information that you shared today on this podcast episode, but from a high level, if there's anything that physicians can take away from this podcast or what you commonly bring up in conversations with them, what would it be?
With physicians, I'm always like, be careful about what you're doing and document. If you have a question, ask a professional. Physicians specifically are really caught in a tough place. A lot of people don't realize that while physicians are expected to know and comply with all of these laws, both on the state and federal level, they typically get very little actual legal training in medical school. For a lot of them, it's one hour class. And that's while they're doing medical school, while they're exhausted and they're trying to learn things that are probably a lot more important to their day to day. And so they should never be afraid to consult with a professional. Again, whether it's an accountant, whether it's a lawyer, whether it's us, whether it's someone else, it's a better idea to talk to someone up front, vet your ideas before you implement them. The other thing that I say all the time is document, document, document. You can have the best systems in place in the world. You can offer the absolute best patient care in the world. If it's not documented in an email, in the EMR system, it didn't happen. And so even when we implement these great systems, I always tell clients, please make sure that you're documenting what you did and why, and do it in real time. So that if we ever do have, whether it's litigation, whether it's an investigation, we can go back and we have a contemporaneous record of what we were doing and why.
So Heather, as we like to wrap up today's conversation, is there anything else that you'd like to leave our audience with?
I would just like to say thank you to all of our healthcare professionals. As you mentioned earlier in the podcast, they have done an incredible job over a really challenging almost 2 years now. Whether it has been changing their practice over to provide more COVID-specific services, whether it's even been having to shut your practice down for a period of time, adapting to telemedicine, adapting to some of the new needs that we're seeing in mental health care that are a lot broader, vaccine rollouts, dealing with vaccine hesitancy. I know that a lot of our physicians are facing burnout, and that's absolutely normal and expected after you have been in an absolute crisis mode for almost 2 years. So I'd like to say that we're here for you. We're here to hopefully take some of that burden off of you. There are also times where, frankly, I almost become the therapist. And even though I am not a therapist by any means, I am happy to listen and I am happy to help. And we are here for you. And we thank you for your service.
Well, speaking of thank yous, thank you, Heather, for taking the time to join us for this podcast episode. And thanks again to all those healthcare professionals out there.
Absolutely. Thanks, guys.